I will now call on Leader of the House to make her reply on her motion on considerations of matter regarding members of Parliament, followed by Ms. Hazel Phua for her reply on her motion on suspension of member. Thereafter, I will put the question in respect of each motion to the House for voting. Leader of the House, you have up to 40 minutes.
Thank you, Mr. Speaker. I would like to thank all members who have spoken on this and made their contributions to this very important debate. I would like to now respond to what has been said by Ms. Hazel Phua and the position of PSP, but also to help members understand the principles and the tenets upon which we should act in such a situation. Insofar as Ms. Phua's and PSP's position is concerned, what does concern me greatly is that it does not, her motion and the move to suspend Minister Iswaran does not appear to come from a place of principle. It is, by her own admission, specifically targeted at Minister Iswaran and not a matter of policy or principle. Now, in order to decide what we must do for this, it is very important to first understand what is the law. And that is why I asked Ms. Phua under which specific provision she was seeking to suspend Mr. Iswaran, because as I understood her argument, which is the same as she has posted on social media, her argument, PSP's argument, is that I want to cut your pay. And because I want to cut your pay, I want to suspend you. In other words, this is the result I want, and therefore I will suspend you. But that is not the correct approach, because when you look at our rules, you will see that generally suspension is a punishment. It is punitive in nature generally. And the cutting of pay is a consequence. So we must first ask ourselves, in what scenario do you suspend, and has that threshold been met? Where do we start? We start with the Parliament Privileges, Immunities and Powers Act, or the PPIPA. The PPIPA does have specific provisions on suspension. Let me deal first with the part that deals with the allowance, because that is where the PSP is coming from. Because it says that Section 29(3) of the PPIPA says no salary or allowance payable to such member for his service as a member of Parliament shall be paid in respect of any period during which he is suspended from service in Parliament. So 29(3) is the provision that says that if you're suspended, then you don't get your pay. But that begs the question, when are you suspended? Well, there's a specific provision in Section 20, which says that for any dishonorable conduct, abuse of privilege, or contempt on the part of a member, Parliament may, and then has various things, may suspend him from the service of Parliament for the remainder of the current session of Parliament or for any part thereof. So there is one specific provision which has a certain threshold, 3 requirements: dishonorable conduct, abuse of privilege, or contempt. But that does not apply in this case. It has not been made out yet. If subsequently something arises out of the investigations that you can say constitutes dishonorable conduct or abuse of privilege, then maybe so, but that has to be considered down the road. But at this point in time, can we say that Section 20 has been triggered? I would respectfully say no. Then there is the next provision, which is Section 19. Section 19 says, without prejudice to Sections 20 and 21, Parliament may, in accordance with its standing orders, suspend any member from the service of Parliament for the remainder of the current session or for any part thereof. So Section 19 tells you to look at the standing orders. So let us look at the standing orders, and that is why I asked Ms. Phua the question earlier. The relevant standing order is Standing Order 59. Now, Standing Order 59.1 has a specific provision on suspension. It states, whenever a member has been named by the Speaker or the Chairman immediately after the commission of the offence of disregarding the authority of the Chair or of persistently and willfully obstructing the business of Parliament by abusing the rules of Parliament or otherwise, then if the offence has been committed by such Member of Parliament, a motion shall forthwith be proposed by a Minister or Parliamentary Secretary present that the member shall be suspended from the service of Parliament, and the Speaker shall forthwith put the question on that motion, no amendment, adjournment, or debate being allowed. Now, whatever else one may wish to accuse Mr. Iswaran of, he certainly cannot accuse him of the conduct listed out in Order 59. There may be others who may, have offended that standing order, but not Mr. Iswaran. So that doesn't apply. So that brings us to the provision that Ms. Phua referred us to earlier, which is Order 59.5. But 59.5 is a general provision, which just basically says that Parliament can move a resolution. So if you're relying on that provision, effectively what you're saying is that because I can pass a motion to suspend you, I will. Now, that's where the question of principle comes in. Should this House do something just because it can? The question is not, should we do it because we can? And even then, I have to put a reservation there because I am not sure that it can be read as broadly as Ms. Phua puts it. But for the sake of argument, just for the sake of argument, it is as broad as she says. We have to, as a parliament and as a house, we have to act on principle. Because if we don't, it becomes very dangerous. Because what it then means is that we can pass any resolution that we like without having regard to values, principles, or standards, and target it specifically at any member of this House. Think about what kind of parliament that would be. What would be the standards of integrity of such a parliament? What would be the sense of fairness? And how would people regard this House if we did something like that? So I would be very, very cautious before we say that we suspend a member just because we can. It is quite important that we should establish the principles of suspension. So when I asked Ms. Phua what is the principles, or what are the principles she's advocating, she listed a few. Let me go through them in turn. First, she said it's because Mr. Iswaran is under investigation for corruption, and corruption is a serious offence. But then I asked Ms. Phua, what about rape? What about murder? If a member is under investigation for those offences, should the member be suspended? Ms. Phua did not have an answer. She said she had not thought about that, which means that she had not thought about the principle. Now, this is worrying because it means that when PSP advocates something, they're not acting as a matter of principle, but as a matter of targeting a specific individual. And that is my concern. And anyway, in any event, whilst Mr. Iswaran is under investigation under the Prevention of Corruption Act, firstly, it has not yet been established whether he has done any wrongdoing, yet, at this point of time. So that, as I mentioned before, the facts are not known, the specific allegations against him are not known. So on what basis do you suspend? The next thing Ms. Phua said was that we should suspend because Mr. Iswaran is on leave of absence. Now, leave of absence in and of itself per se cannot be a reason for suspension. If that was so, then we would have to suspend Mr. Faisal Manap. He was on leave of absence because he was ill. But we don't do that because he was ill. And, you know, so in other words, it is not the leave of absence in and of itself. It is the reason. It is the reason why you have to take leave of absence. And in this case, Mr. Iswaran was effectively asked to take leave of absence because it's untenable. He cannot perform his duties as a minister, and it will be very difficult for him to perform his duties as an MP whilst under investigation. So, as a matter of proper good order, he should be on leave of absence. Then, the next point that she made was that was because he was under arrest. Well, yes, when you're under investigation, the part of police procedure is that you're under arrest, but I come back to the same point. This is still at the investigative stage, and you have not actually established whether there was any wrongdoing. So then she made the next point that he was not performing his duties. Here, let me just make a very short digression to say that whilst he has not been able to perform his duties as an MP, his constituents are still being looked after. I wanted to make that point because it is very important that his constituents know that they are still being taken care of and in good hands. In fact, Minister Desmond Lee has been doing the Meet the People session. He and another MP, I think Ms. Rachel Ong, have been doing house visits. The other MPs in West Coast GRC have been covering events on the ground. So I just wanted the residents of West Coast GRC to know that notwithstanding the fact that Mr. Iswaran has to be on leave of absence, they are still being taken care of. Then Ms. Phua talked about the question that, well, it is, if it's taxpayers' money that is being used in the interim period. But the important question is, what is the principle? You don't suspend somebody just because you don't want to pay him. You have to suspend him because there is a principle that has been breached or a threshold has been crossed. Now, it may well be, depending on the outcome of the investigations, that threshold may be crossed. I don't know. None of us know at this stage. So that is why my motion at this point in time says that we should wait until the outcome of the investigations before deciding what to do, simply because that threshold has not yet been met. And on this, I note that the leader of the opposition had also taken a similar position, for which I do thank him, because he said Parliament should be very mindful of suspending somebody in the meantime, and this would set a precedent should the government decide to fix anybody. And he also talked about the wheels of justice and that we must not do anything unprecipitated, not the leader of the opposition's words, but essentially what he's really saying, which is the same thing as what others have said, is don't prejudge the issue. And that is correct, because the leader of the opposition and Mr. Faisal Manap are under investigation. They were referred to the public prosecutor. And on that, I just also want to say that when you look at the way that we approached that, we did not suspend them because we felt that it was better for the outcome to be heard. In fact, we went further in that case because here in this motion, I am only asking for us to wait till the outcome of the investigations. In the case of the referral to the PP on the Committee of Privileges inquiry for Mr. Singh and Mr. Manap, we actually said that we would wait till the outcome of the proceedings. Let me just read from the relevant report, because the COP's recommendations were that Mr. Singh be referred to the public prosecutor for further investigations with a view to considering if criminal proceedings ought to be instituted in respect of his conduct before the committee, and that Mr. Faisal be referred to the public prosecutor for further investigations for his refusal to answer relevant questions put by the committee and consider if criminal proceedings ought to be instituted. And what the Committee of Privileges said, the recommendation was this. Based on the evidence before this committee, we're satisfied Mr. Singh had told untruths to this committee. Parliament is empowered to summarily decide on the matter and also decide on the appropriate sanctions based on our findings. However, we recommend that Parliament refers Mr. Singh's conduct to the public prosecutor with a view to consider the institution of criminal proceedings. We would also recommend that Parliament consider deferring any action to be taken in respect of possible dishonourable conduct and contempt of Parliament until criminal proceedings, if any, are complete. The point I want to make is this. The specific offence in that case was dishonourable conduct and contempt. That falls squarely within Section 20 of the PPIPA. The COP had made its finding with regard to Mr. Singh and Mr. Manap. Mr. Singh and Mr. Manap, of course, dispute that. I understand that. And that was the reason why we said it should go to public prosecutor. But this House, the Committee of Privileges in this House, would have been well within its rights to say we accept the findings of the COP and we act immediately under Section 20. But we didn't. We didn't because we felt that as a matter of fairness, we should wait and see what the outcome of the proceedings were. And so the actual resolution which I moved, let me just see if I can find that. Yes, the resolution which I moved was this, that Mr. Pritam Singh's, Ms. Sylvia Lim's, and Mr. Mohammed Faisal bin Abdul Manap's respective roles, as set out in the report, in relation to the untruth spoken by Ms. Raisa Khan in Parliament, and Ms. Lim's or Mr. Faisal's stating of untruths to the Committee on Oath or Affirmation, and the appropriate sanctions in respect thereof, be deferred until the conclusion of the investigations and criminal proceedings, if any, against Mr. Singh. So in that case, I went further and I said, wait till not just the conclusion of the investigations, but the conclusion of the proceedings. In this case, I'm saying, let us wait until the conclusion or the outcome of the investigations, because that would put this House in a better position to know what to do. Now, let me just come back to some of the other questions that were asked. Mr. Singh had a question because I think Mr. Singh supported the aspect of supports the position that Mr. Swan should not be suspended at this point in time, I think. His second question, though, was what should Parliament do in the interim period? And I think his position was that it might be appropriate to suspend his MP allowance. That's what I think Mr. Singh said. The difficulty with that, and this is what Ms. Phua was alluding to, is that there's no provision in the PPIPA currently to suspend allowance. It's a binary position. If the person is a sitting MP, he receives the full allowance. If the member is suspended, then he doesn't get any allowance. So the law does not provide for anything in between. Ms. Phua mentioned that she had, in the original motion, wanted to provide for clawback, but was advised by Parliament, which I think is the current position under the law, that there is no provision for a clawback. So the question is, what do we do? Currently, right now, given the state of the law, and given that we don't know the facts, and that we don't know the outcome of the investigation, that's why I have said we should wait till the outcome of the investigation, then we have a clearer idea of what to do. And the next question then is, well, what should we then do with respect to the monies that are paid with respect to Mr. Iswaran? Well, I think the answer is this. We will look at it again when we know if the Attorney General's Chambers intends to bring any charges, and if so, what the charges are. We will consider a clawback if justified. If he is charged, the Prime Minister will consider the allegations, the accusations against him, and decide whether to make him resign and to pay back both salary and allowance without waiting for legal process. Now, bear in mind, this is a party discipline matter. It's a party discipline matter. On the basis that and the Prime Minister would do this on the basis that he has not lived up to party standards and party discipline and standards of conduct, whether or not he has committed offences. And if it's really necessary, then we will consider what to do with respect to legislation. But there will be issues there, so that is the reason why I say, again, that these are issues that should be considered when the outcome of the investigation is known, because it may very well be that at the end of the investigation, he's also cleared. And if he's cleared, then what we would have done in the meantime, if we accept Ms. Pua's motion, is that we would have suspended him and we would have doctor's pay when there was, in fact, no need to. So, at the end of the day, it's a question of where is the balance? What is a fair way of dealing with this, given the current state of the law, given the current state of knowledge that we have? Ms. Pua's approach is really, let's just ignore whether or not he's done anything wrong. Let's just suspend him because it's a matter of money, and then if need be, we pay it back. But I think we need to approach it as a matter of principle, which is that at the current time, when you cannot say clearly that some threshold has been crossed, then we say, wait, see what the outcome of the investigations are, and if, depending on the outcome, a threshold has been crossed, then we will certainly look at it as a matter of party discipline, and the Prime Minister has very firm views on standards of integrity and conduct, and he will not let the matter rest if thresholds have been crossed. I think that assurance I can give, which is that if certain thresholds have been crossed and if warranted and merited, we will do something. As to what exactly we will have to do, well, we'll have to see what happens, but I've said quite plainly that we will certainly consider a clawback and also think how to do it. So I hope that that sets members' minds at rest, because if we don't suspend him today, it does not mean that you cannot do so in the future. If you do suspend him today, you're effectively saying that he has done something wrong when there is no basis at the present time. There may well be later, we don't know, but at the present time, it will be premature and prejudging the issue. Please.